Okay. We're on the record as the people versus Marco Williams, case number 2355250. Mr. Williams is charged with count 1, robbery armed. Count 2, intent to rob armed. Count 3, unlawful imprisonment. Count 4, weapons, felony, firearm. Count 5, weapons, felony, firearm. Count 6, weapons, felony, firearm. Today's day is set for a probable cause conference appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Michael Lamb, P79816, appearing on behalf of Mr. Marco Williams. Your Honor, Mr. Williams is not present this morning. He is in the hospital. I will respectfully request that his appearance be waived for today's probable cause conference.
Okay, I have no problem with that.
Your Honor, we are at this time demanding the preliminary examination. I would note that I have received a paper and electronic discovery. That electronic discovery includes some 79 plus files, Your Honor, that I just received yesterday. I haven't had the opportunity to review those or go over them with my client. Obviously, I'm saying that to say, Your Honor, that I expect that going to take me some time to do that. I'm requesting a preliminary examination outside of the 21 days. I have communicated the 21-day rule to my client, and he is okay with the waiver of the 21-day rule.
Okay, how about February 24th?
February 24th, give me one moment, Your Honor. I'm accessing my calendar here. Will that be in person or Zoom?
It will be in person.
In person, February 24th?
Yes.
I am available, Your Honor.
Okay, and because he'll probably be in custody, we'll have to do it after 9:30. So does 10 o'clock work?
It does.
Okay, so February 24th, 10 o'clock in person. And just for clarity, Attorney Lamb, your client is still in the county jail, but he's in the infirmary.
That is my understanding, Your Honor, yes.
Okay. Anything else?
Not at this time. Thank you so much. You have a wonderful day.
You too. I'll see you on the 24th.
All right. Thank you. See you then.
If you have a traffic matter, you should be at Judge Larry Williams courtroom 332. Mr. Rockmore, have you checked in? I'm waiting for your attorney. Attorney Demont Gray.
Good morning, Judge. I'm here on Joshua Jordan.
Mr. Jordan is not checked in.
Yes, Judge, I reached out to your courtroom because Mr. Jordan is currently in the St. Clair County Jail, and I'd ask if it's possible to, do a writ for him.
Actually, is his name Joshua Jackson?
Jackson, I am sorry. I'm running between things. Yes, Jackson.
Okay. So a writ for the preliminary exam or for a PCC?
Just for a PCC.
Okay. And you said you do know where he is?
Yes, I have confirmed and I've spoken with his mother, Miss Katrina Jackson, who should be watching this YouTube. But yes, he's there as of last night when I checked St. Clair County again.
Okay, so how long does it take? So a writ takes 2 weeks.
Okay.
Let me check.
Do they do Zoom over there? If it's a PCC, you don't need them to come here.
All right, you don't need a writ for a PCC, you can do Zoom.
If they do it, Zoom, yeah.
Yeah, a Zoom writ.
Oh, okay, I thought you meant in person.
Oh, I apologize.
I was thinking exam. Okay, so how about we set it out 1 week?
Yeah, 1 week works for me.
Okay, so today is the first, so February 8th, PCC, we'll make sure we have a Zoom writ.
Okay, perfect. Thank you.
You're welcome. Have a good day.
You as well.
Thanks. Oh, I'm sorry, I didn't give a time. Yes, I put on the record 9:00. And once she calls back, you know. Attorney Reed, good morning.
Come on. Antonio. No, PCC. Where is it at?
Attorney Reed, good morning.
Good morning, how are you?
I'm fine, how you doing?
Hi.
Your client has not checked in yet.
Well, we can waive his appearance if the court would allow.
Okay, this is an exam date?
Yes, please.
Okay. Antonio Moore. We're on the record as the People versus Antonio Moore, 2355278. People versus, I'm sorry, Antonio Miller. Case number. The right case? The front case number. Mr. Miller is charged with 1 count of controlled substances, possession, cocaine, heroin, or another narcotic less than 25 grams. Today's date set for a probable cause conference appearance.
Alexander Kirker on behalf of the people, key 86282.
Good morning, Your Honor. May it please the court, Daniel Reed, P number 30965, appeal on behalf of Mr. Miller. We do consent to this matter proceeding by zone and ask the court to allow us to waive his appearance at this time.
And you have been in contact with your client?
I have, Your Honor.
Okay, I will waive his appearance for setting the exam date. Are there any discovery issues?
No, Your Honor.
Okay, so I have the 22nd, 23rd, and 24th available.
Not just 20 seconds. Okay, you said May 22nd, 23rd. Did you have a third date?
24th.
That's good. The 24th is good.
Okay, the earlier the better.
All right. We could say 9 o'clock if the court would allow.
I would love 9 o'clock.
Okay, 9 a.m.
9 a.m. February 24th.
All right, we love this court. Thank you very much.
Welcome, have a good day.
They say.
Francois Fleming.
Hello.
Yes, sir, what are you here for today?
Oh, tickets.
Traffic ticket?
Yes.
Okay, I'm putting the information on the screen. You should be in Judge Williams' courtroom at 332.
All right.
Take your time and take the info down.
I have it.
Okay, go ahead and log in now. Have a good day.
You too.
Ms. Ford, Marlisha Ford.
Yes,
Did you disconnect and come back on?
can you repeat that, Your Honor?
Did you get disconnected?
You said it, did I get disconnected?
Yes.
No.
Okay.
You got one lockup coming over at 10. Jacob Smith.
Term restriction, that's what we were going back to look at, the attorney, she's like, so I'm taking the full value. So I was like, okay, well, fine. Attorney Brown, good morning.
Good morning, Your Honor.
You have Mr. Rockmore, correct?
Yes, ma'am.
Okay, you need to speak to him before we go on the record?
If I may have a brief breakout room, I'd appreciate it.
Sure, Mr. Rockmore, I'm going to put you into a breakout room with your attorney so that you can speak to him privately, okay? Go ahead and unmute your device too.
Saying yesterday? Who said? No.
Yeah,
Well, I didn't do it quite yet.
The prosecutor that day.
yeah. You wanna, you trying to do the breakout room in my living. So, yeah, it's fine.
Might be wrong.
Did you? Okay. Attorney Tucker, Tarleton will probably come up as soon as we get done with Rockmore.
I'm sorry, Your Honor. What'd you say? I didn't hear you.
Your client will probably be next after we get done with Rockmore.
Okay, thank you.
Is it pretty one? Yes, sir. Okay, you want to take the Zoom in now? There it is, hold on. Okay. Your attorney has to take. Any pictures? Officer Orvet for Nakia Jones. Officer on Nakia Jones. Gentlemen, what's your name? Get that down, the county division 1. So the gentleman who just sat down in the Wayne County Jail, what is your name?
My name is Reginald Orlando Tarleton Jr.
Okay, your attorney is here. Attorney Tucker, do you need to speak to him in private before we go on the record?
No, Your Honor, I've already had a chance to speak with him.
Okay. Okay, this is case number 2355271, the people of the state of Michigan versus Reginald Orlando Tarleton Jr., who was defendant number 2 and charged with 1 count of robbery armed. Today's date set for a probable cause conference. Appearances.
Alexander Kirker on behalf of the people, P86282.
Good morning, Your Honor. Tamika Tucker, PA 5402, on behalf of Reginald Tarleton Jr., who's present on Zoom in Wayne County Jail.
And Mr. Tarleton, can you state your full name for the record, please?
Reginald Orlando Tarleton Jr.
Good morning. And do we have any discovery issues?
No, Your Honor, I just received paper and digital discovery yesterday. I have not had a chance to go through it, but I do have it.
Okay. Since this is a 2 defendant case, I do want to wait for Attorney Brown to come out to see the date works for him that I want to suggest for the exam. There he is. So Attorney Brown, I just called the co-defendant in this case, so I'm going to call Mr. Rockmore as well, as long as you're ready to go.
Thank you, Your Honor.
Okay, so also on case 2355271, the people of the state of Michigan versus Gregory Aaron Rockmore, and Mr. Rockmore is charged also of count 1 of armed robbery, and he has an habitual offender 3rd offense notice. Appearance for Mr. Rockmore.
Good morning, Your Honor.
People, P86282.
I'm sorry. Good morning, Your Honor. May it please the court. My name is Mark Brown. My P number is 39562. I'm here on behalf of Mr. Gregory Rockmore, who's present from the Wayne County Jail via Zoom. We have no objection to continuing this hearing via Zoom technology. Mr.
Okay.
Rockmore, state your name for the record.
Thank you.
Gregory Aaron Rockmore.
Thank you.
Okay, and all we discussed on Mr. Charlton was whether or not discovery was received. And do you have discovery at this time?
I do have what was sent to me by the prosecutor. I believe it's complete. I'm not sure.
Okay. As both individuals are in custody, I have a couple of times on the 15th that will be earlier than the normal dates of 22nd, 23rd, and 24th. If the 15th you will have available, I can do it on that day.
I think there's no
Judge, I have an exam in Inkster at 11 o'clock in the morning, so either before or later, I can do that. Do it at 9 o'clock or something.
That's what I have open, 9 o'clock.
Okay, great. Great.
Your Honor, I am actually in court at 9 o'clock over at Third Circuit.
That moves the exam to the 22nd, 23rd, or 24th.
You can do it on the 22nd.
I can do it on the 22nd also.
How about 9:30?
That works for me.
That's fine, Judge.
Okay. Anything else?
No,
Yes, Your Honor, I would like to address my client's bond.
I still don't have a DSU report.
Okay.
Once I receive
Judge-
the DSU report, I can have the clerk call you and set up a date in between the 22nd to address it. But he had his bond redetermination hearing, and I ordered a DSU because I didn't want to change his bond based off of what I received, the information I received.
Okay, thank you, Your Honor.
And Judge, is there a DSU, was there a DSU ordered also for Mr. Rockmore?
Yes, let me make sure. I have to check my notes. to
Thank you.
confirm. I think I ordered a DSU on both. I did, okay, so they should come in the same time. As soon as I the court receives it, I will notify you all.
Thank you very, very much, Your Honor. Mr. Rockmore, I'll be over to see you.
Have a good day.
You both have a good
Thank you.
day. All glory be.
Thank you.
The person with the iPad and no video and muted right now.
My name is Ludwig. Say that.
Mr. Rockmore, you can let the deputy know that your case is finished for today. Your next court date is February 22nd.
Okay.
All right? And Mr. Charlton, same thing. Your next court date is February 22nd.
No bond, I have no bond reduction or no bond, nothing.
So I don't know if you heard us talking on the record. I ordered what we call a DSU report back when you had your bond redetermination hearing. As soon as I receive that report, I will not contact your attorneys and you can come back before the 22nd to address bond. But I have to have that report before I can address bond again.
Okay, thank you.
It's supposed to be 5 days from the date of our bond, from the date of your bond redetermination hearing, but it hasn't come in yet. So it should be in the next week. So when I have that, I can have a better idea of what to do with your bond. But at the time, I'm not changing it based off of based off the hearing we had.
Okay,
Right? So you all, both of you all are all set for today. As soon as I get a report, I will have the clerk contact your attorney.
All right, appreciate it.
You're welcome. You all have a good day.
Yep.
I think we're done. with it. I think we're done. with it.
Hello, Your Honor.
Oh, yes, we're done. We're all set. Thank you.
Appreciate it. Have a blessed day.
You too. Thank you.
We got one downstairs for the exam.
Who is it?
Jacob Smith.
Jacob Smith.
Well, they haven't called and told me he got here yet.
As soon as he gets here, I'll call the monitor so we can get moving. I have you checked in, Mr. Bueno. Officer Oravet.
Yes, good morning. Sorry, I joined the first time and then my department phone decided to restart 3 times.
Oh, you're supposed to be in Judge Larry Williams now. I'm not on traffic anymore.
Oh, okay. Do you by chance know his room number?
I do. Let me know when you're ready.
Go ahead.
360-332-0000.
Great. Thank you so much. Have a good day.
You too. Can I have David? Wait, no.
Zoom in a different way because you were in 332, right? So they're not, if they zoom into that, they will get you.
They're zooming in from the website, just hitting Judge Sabree.
Oh, okay. And then bring it right here. Okay.
Because there's like a comment, they just hit Sabree. Not moving to- Well, the notices too say 332 still, because they have cases scheduled out to August. So the notices that went out have 332 or have Judge Sabree. It still has 332.
I was talking about the police officers.
Oh.
I thought they would be familiar with 332.
Officer Crawford, good morning.
Good morning. I am actually looking for Judge Williams' courtroom. They said 335, but that was Yancey's. And then,
That's wrong. 332.
oh, it's 332. Okay. All right. Thank you.
Oh, you got it?
Yeah. 332, you said?
Yep.
All right. Thank you.
You welcome. Ms. Bean? Yeah, you're right. I don't know. Ms. Bean?
Yes,
Good morning.
good morning.
What are you here for today?
The tenant landlord.
So that's my brother. He's at court. Oh, I don't know what courtroom he's in. So it's Adam Sabree. We got 2 Sabrees now.
Uh-oh, it's a who?
It's Adam Sabree. I'm Aliyah Sabree. He's Adam Sabree.
Oh, God. Okay.
So are you zooming in from the website? Is that how you're finding the courtroom?
Yes.
Okay, so go to Adam Sabree. I'm not sure, he's moving courtrooms because he doesn't have a courtroom yet, so just go to, do you have a courtroom number attached to your notice?
Well, I never got a notice. My lawyer just called me yesterday and told me. She said she didn't even know.
I don't know either. Hold on, let me make sure. You don't find we coming back to the. Okay, the normal 3605. Okay, Ms. Bean,
Yes.
it's 360-533-0000.
Okay, thank you.
And if you do it from the website, just go to courtroom 533. It won't, it might not have a name attached to it. It's courtroom 533.
Okay, thank you.
You're welcome. Have a good day.
You too.
Attorney Watt, good morning.
Good morning, Your Honor. How are you this morning?
I'm fine. How are you doing?
I'm doing well, thank you. I'm here on Miss Ford.
And she's here as well. Do you need to talk to her before you go on the record?
I still do not have discovery. And so, yeah, I could just talk to her because I still haven't received this discovery.
Okay. Ms. Ford, unmute your device. I'm going to put you into a breakout room with your attorney. For disqualification. For disqualification. Attorney White, I'm bringing your client out. It's taking a minute.
That's okay, Your Honor.
Okay, we ready to go on the record on Ms. Ford?
Yes, Your Honor.
Yes.
Okay. This is the people of the state of Michigan versus Marlisha Ford, case 22-60868. Ms. Ford is charged with count 1, assault with a dangerous weapon, felonious assault. And count 2, weapons, felony firearm. Count 3, assault or assault and battery. And this is a habitual offender second offense notice. And for the record, Ms. Ford is defendant number 1 on this case. Appearances.
Alexander Kirker on behalf of the people, P86282.
And good morning again, Your Honor. Coral Watt appearing on behalf of Ms. Ford, P41508.
And Attorney White, you stated briefly off the record that you have not received discovery yet, is that correct?
Yes, Your Honor.
Mr. Kirker?
Yeah, we're still also waiting on discovery, but as soon as we have it, it'll be sent over.
Okay, in that case, Your Honor, I'm requesting a second PCC date since there's not a time certain that the prosecutor can tell me when that discovery will be available.
Okay, do you want to set an exam date as well?
I mean, I could, but it's the prosecutor. If we set this date, will you be able to guarantee me that I will have the discovery prior to the exam date? I'm asking the prosecutor.
I can't make a guarantee, but try to reach out.
Okay, how much time
Then
do you want or need for the record work?
A week or so.
Okay, how about February 9th? Come back to see if discovery.
Yes, Your Honor, that's wonderful. February 9th would be great.
Okay, 9 o'clock?
Yes, Your Honor. And then I have one other matter that I would ask the court to allow me to address.
Sure.
There is a provision, I guess, that was put in place either by the court or the magistrate. It's a pretty standard provision. It's directing my client not to go to her former address because the complainant lives in the area. My client's asking if the court would consider lifting that restriction because the complainant no longer lives in the area. And we're asking, she still has mail that comes to that address that she has to periodically go over to retrieve. So we're asking if the court would consider striking that requirement.
So
and I don't know.
I'm sorry. Ms. Ford just needs to go pick up mail from there?
Yes, from her old address. She moved from the old address, which is in the same or was in the same area where the complainant used to live. She's at a new address now, but she still has mail that is coming to that address, even though she's changed her address. She has changed it with the post office. And so she wants to be able to periodically go over and get her mail.
Anything from the people?
People leave it to the discretion of the court.
Attorney Watt, how do we we know that the complainant was moved?
And I was hoping that the prosecutor could verify this. It's my understanding that the complainant was evicted. And if the prosecutor can't verify that, I understand, but that's information that was relayed to me by my client.
I'm concerned that she knows that, your client knows that information as well.
She knows the information because they have neighbors in common. My client lived there for about 10 years, so she knows all of the neighbors in the building. And the complainant, I think, had only lived there for like a year or two.
Okay, Ms. Ford, can you put your name on the record? I forgot to ask you to put your name on.
Marlisha B. Ford.
And Ms. Ford, you just need to get your mail periodically? That's what your attorney is stating.
Yes, Your Honor. Basically, I, changed it over. I only been living at my new address for only like a month. So I, like my W-2s and like my, stuff that's related to like DHS, like my BRIAS card and stuff like that. Like it hasn't switched over to my new address. So they still sending things to 1303 West Forest. And Carmela Padwin, she was evicted in July. She never was supposed to even be still over there after that, but she still was. But, she doesn't live there anymore. And I know that. And like I said, I'm not trying to come in contact with her. I never was in the first place. She's been gone before me. Before I left, she was already gone.
How would you get the mail then if that person?
Well, my kids also go to school over there still.
So she knows, she's asking you, how would you have access to the mail if you no longer live?
Oh, I have a key. I have a key to my mailbox still.
Because the apartment has not been rented out yet, Your Honor. So
it's vacant. Like the apartment where we stay in, like the landlord is like a slumlord. They don't take care of anything. It's abandoned. Like it's still got like abandoned apartments, including Carmela's. Mine is still abandoned.
Okay.
And so like, yeah.
Thank you, Ms. Ford.
Thank you.
Ms. Ford, I will allow you to send someone over with the key to get your mail.
That's fine.
Without that verification that the complaining witness has actually moved.
Thank you, Your Honor. So she'll send a family member or someone over there with the key to get her mail. And she was just concerned because it is tax time and she has a lot of important documents that will be coming here.
Okay, so Ms. Ford, the only reason why a family member with the mailbox key should be at that location is to pick up your mail. Do you understand that?
Yes, Your Honor, I definitely do.
Okay. Anything else?
Nothing further, Your Honor. Thank you.
Okay, I will put note of that in the record to change the bond condition.
Thank you.
All right, so I will see you all on the 9th, hopefully with some discovery. We can set an exam date.
Thank you, Your Honor. Have a good day, everyone.
You too, both of you.
Thank you.
You're welcome. Attorney Bueno, I'm sorry, Attorney Bueno. Mr. Bueno, have you talked to your attorney? Mr. Chris?
Your Honor, are you speaking with me? I'm sorry.
Yes, have you talked to Mr. Cripps today?
No, I was just actually called his office that's online, and some female answered and didn't address who she was, and she just hung up on me. I've been severely hacked, so I'm on a different device now, but no, I have not spoken with my attorney, Judge.
All right, we're going to contact him, see if we can get him on. So.
I appreciate that. I have a new number. I let pretrial know that, and I was just trying to call his office and let him know that. But thank you so much, Your Honor.
Coming up, get you some papers.
So the woman who just logged on, in the vehicle, what's your name?
How you doing?
Oh, what's your name, sir?
Good morning.
Hi, what's your name, sir?
Aaron Varner.
Okay, you should be in courtroom 332 of Judge Larry Williams.
332?
Yes, I'm putting the information on the screen so you can take it down and log in as soon as you get the information.
332.
Okay, thank you.
You're welcome. Have a good day.
Wait.
There goes the number.
Good morning, Attorney Cripps.
Good morning, Your Honor. I apologize for not being here sooner.
No, that's fine. We just had a dead period before the exam started. I was trying to get you in before we started it.
Thank you.
Okay, do you need to speak to your client or are you ready to go on the record?
I'm ready to go on the record, Judge.
Okay. All right, this is the people of the state of Michigan versus Mario Bueno. Case number 2260355. Mr. Bueno is charged with count 1, breaking and entering a building with intent. Count 2, larceny in the building. Count 3, malicious destruction of personal property. $1,000 or more, but less than $20,000. This is a habitual offender. Third offense notice today is set for a probable cause conference. Appearances.
Alexander Kirker on behalf of the people, Pete 86282.
Good morning, Judge David Cripps, P34972, appearing on behalf of Mr. Bueno. Absolutely no objection to Zoom. Thank you.
Mr. Bueno, can you unmute your device and state your name, please?
Yes, Mario Bueno for the record, Your Honor.
Okay, and before we begin with the discovery of the lease issue, I remember that last time, I did speak to Attorney Cripps and Mr. Kirker off the record to determine or discuss whether or not I needed to disqualify myself. I just wanted to place on the record and notify both parties that I do know Mr. Bueno from working in the mayor's office. Mr. Bueno did not work in the mayor's office, but he worked with the program. And from that, we have known each other since. I have not communicated with Mr. Bueno. I don't have his phone number. Then he also did send flowers to the court to congratulate me for winning my election or coming to the bench. And according to court rule 2.003, which states disqualification of judge, allows for me to bring that, raise this issue, and I am bringing it to both parties. If you find, or you all find that there are grounds to disqualify, I will make sure I do that and transfer it to another judge, or under court rule 2.003, section E, there's a waiver of disqualification where both parties may find their grounds based off of it and decide to move forward or willing to participate and not disqualify. So it would only be under court rule 2003C1A, where it says the judge is biased or prejudiced for or against any party or attorney. I think that would be the only section that applies. I do not believe that I will be prejudiced for or against, or biased for or against Mr. Bueno, but I leave that to both parties to determine. So I will start with the people. Mr. Kirker, do you have anything you'd like to say?
I have no objection.
Judge, on behalf of Mr. Bueno, I know how professional this honorable court is. And I know that there'd be absolutely no issue whatsoever. You would make the absolutely right call on any decision you make. We certainly have no objection whatsoever in maintaining our case on your docket.
Okay, I just needed that on the record. So with that, Mr. Cripps, did you have any success with finding the lease that Mr. Bueno was looking for?
No, Your Honor. I thought the prosecutor was going to check with the officer in charge based on the record we made last time, because the officer in charge visited the complainant personally and received a great deal volume of documents from the complainant regarding this case, and we're hoping that that included the lease that we were requesting.
I have reached out to the officer in charge. I have not heard back yet on specifically about the lease.
Would you reach out to the officer in charge?
I know after the last PCC that we had.
Okay, so that was January 25th. Still nothing from the OIC.
Judge, could I then prepare a special order of discovery to serve upon the officer in charge?
Yes. How much time do you need for that?
Well, I can get that done by tomorrow and email it once I get the officer's email address. directly to her.
Okay. And you want this for another probable cause conference?
Yes, please, Your Honor.
One more week?
Yes.
And do you need the email address for the OIC?
Yes, I do.
I won't relay it over Zoom. Let's see, Mr. Kirk, do you even have it? Okay. So I'll send in the chat, Mr. Kirk, so you can have the email address.
Thank you, Your Honor.
Okay, so we'll set this for one more week out. Today is the first, so it'll be the 8th, February 8th at, do you want 8:30 or 9 o'clock?
I could briefly check my calendar here.
Okay.
The earlier the better for that day. Anytime, I'm there for an exam at 11, so anytime you want, it's fine.
I like 8:30.
Thank you.
Okay. And I will send the information to your chat for the email address. So Mr. Bueno, you can Zoom back in on the 8th. You don't have to be in person, okay?
Thank you, Your Honor.
You're welcome. You can log off if you don't have any questions.
Thank you, Judge. I'll wait for the chat.
Thank you.
Okay. Mr. Willie Jones, we're off the record.
Yes.
Do you have a traffic matter today?
Yes, I do. It was for 8:30.
Okay, you're in the wrong courtroom. I'm putting up the information so you can get to the right place, okay?
Okay, thank you.
You're welcome.
Please.
During PCC on that, Mr. Riggins is here. He hasn't talked to his client. I'm glad you're here because I'll have my key set in my car. Oh, let me go put my weapon. One year, please.
Okay, I just did it over, Mr. Chris. What, right, Malone? Is it Malone L or Malone 1?
Malone L.
Oh, wait, hold on, Malone L. Okay, that's Malone L.
Larry Williams,
Okay, we are on the record. This is the people of the state of Michigan versus Darrell Jerome Thomas, case number 2260955. Mr. Thomas is charged with count 1, controlled substances, possession, cocaine, heroin, or another narcotic less than 45 grams. Count 2, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 3, weapons, firearms, possession by a felon. Strike that. I did not see this. There are 2 defendants on this case. Mr. Darrell Jerome Thomas is defendant number 2. He's only charged with count 2, controlled substance, delivery, manufacture, cocaine, heroin, or another narcotic less than 50 grams. Count 3, weapons, firearms, possession by a felon. Count 4, count 5, weapons, felony, firearm, and this is a habitual offender 4th offense notice for Mr. Darrell Jerome Thomas. Appearances.
Alexander Kircher on behalf of the people, P862282.
And good morning, Your Honor. Good morning to your staff, Neighborhood Defender Services by Ken Riggin, T82125, on behalf of Mr. Darrell Thomas.
Good morning. And today set for a preliminary examination. Are both parties ready to proceed?
People are prepared, Your Honor.
Your Honor, respectfully, defense is not prepared. My client is not here. I have tried to reach him. I have no explanation for his non-appearance at this point.
And you also stated that attorney Epps Ward was assigned to this case before you, and she did make contact at some point with the defendant.
That is
Your
my
client?
that is my understanding. Yes.
Okay. So the time is 10:05. The people are ready to proceed. Today is the date set for the preliminary examination. Anything for the people?
Yes, for yes, Your Honor.
I will issue a case. It'll be a personal $1,000. And of course, if your client appears or reappears, show them.
Your Honor, I will send my investigator out to see.
I didn't hear the last.
Yeah, I said I will send my investigator out to see if we can locate Mr. Thomas.
All right, you're off the record.
Thank you.
You still. What happened with the codefendant?
Good morning. That's it. It's Woodside. I thought he was for the second, not today. Madam Clerk? It's the first, not the second.
Attorney Woodside, are you there?
I am.
All right, good morning, how are you?
Good morning, Judge. Can I leave my,
This is Serena, the clerk. I stepped out and I was in the back. I apologize. We're between cases. But Attorney Woodside, we have you for Demetrius Davis for
my
probable
appointment
cause
says February 2nd.
February 2nd.
Yes, ma'am. I've talked to Mr. Davis because he just asked me. But it says February 2nd. Today is the 1st, correct?
I hope so.
And I'm like, you know, I know I'm slipping, but not that bad. Can you see it?
Now in the system, Attorney Woodside actually has the 1st.
Okay, well, I only know what's on the appointment. Wait a minute. There's nobody in the courtroom but you guys, right? Okay, so let me. Okay, because I don't want you to see. I mean, I just took my clothes back off. Can you see it?
We can see it.
25,000 cash surety.
Yeah, I have the same thing, but I have 2-1. Okay, Judge Sabree is in her chamber, so let me walk down and explain to her what's happening here, okay?
But you know what? I can do it today if she lets me waive his presence. I know where he's at, 'cause we got to be in court tomorrow on a whole nother issue anyway, over in circuit.
Okay, so.
So I can do it today without him and get an exam date.
All right, give me just a second, Madam Counsel.
Thank you, ma'am.
No problem. Run down. I'm gonna run down. I'll be right.
Good morning.
Attorney Woodside, are you there? Can you hear me?
Hear you loud and
Okay.
clear.
I just spoke with Judge Sabree and she will allow me to give you an, are you trying to, I guess I should ask, are you looking for an exam date next?
I am, please.
Okay, so she has the 23rd at 8:45, 9 o'clock, 9:30, as well
Wait,
as.
you
the
said
24th.
February 23rd?
Yes, you can check that, 8:30, 9 o'clock, or 9:30.
That's the latest. Ugh.
Yeah, she has the 20,
Well, the problem is that I have a trial the 21st and the guy has 3 cases, so I know I'm gonna be stuck in trial. That's a problem.
Okay, so these are the dates she left. Attorney Woodside, she said she'll be up in about 3 minutes. So when she comes up, we'll just go from there, okay?
Okay.
Thank you.
Yep, I'm here, but I'm just gonna do something else.
Okay, thanks a lot.
Bye.
Miss Attorney Woodside? Attorney Woodside, can you hear the courtroom?
I can.
Good morning, Attorney Woodside.
Good morning, Judge.
So we apparently had the wrong day.
Yeah, I was telling Madam Clerk and showing her my appointment says February 2nd.
Okay, and I didn't issue a capias because it seemed strange that neither one of you showed up. So
Now, Judge, you know about, I'm getting, my new excuses. I'm 65. Now, occasionally I can forget things, but I try not to forget the court dates.
yeah, and this wasn't one of them. So you
Wait.
get dates outside of the 24th?
Yeah, because I've got now, that we're doing back-to-back trials. And so I have a client with 3 trials. I could, if the court would let me, I could waive his presence and set a date, but I'm gonna need a minute. Because the 23rd is, so I got Harris on the 21st and he's got 3 trials.
Okay.
So I know we won't be done.
Okay, I'll call
Probably
you.
till sometime in the following week. Let's see.
All right, that's fine. Okay, we're on the record as the people versus Demetrius Rashid Davis, 2355285. Davis is charged with 1 count of robbery unarmed. They set for a probable cause conference appearances.
Alexander Kirk on behalf of the people, P86282.
Again, very good morning, Your Honor, to you and your staff. Sharon Clark Woodside appearing on behalf of Demetrius Davis. I'd ask the court to allow me to waive his presence. I am in constant communication with Mr. Davis, and we won't have objection to waiving 14 days.
Okay, to both, okay to a waiver, and thank you for no objection to outside the 14 days. So do we have any discovery issues on this case?
No, I have discovery. I have received at least a paper discovery. I don't know if there's digital. I haven't received that yet.
Okay, Mr. Kirker.
I have the full paper and digital were sent over on the 30th.
Yeah, I got paper from out of Carpel. So when did the digital come?
January 30th. That would have been through evidence.com.
Because I'm going to look for it as we speak. Oh, that's not what I wanted to do. That is not what I wanted to do. So I'm going to have to look for that email. I don't know why it would be. You said the 30th?
Yes.
Just one moment, please. I'm looking at 28. How about I do this search? So am I to understand paper is Carpel and everything else is still evidence.com?
Yes, that's correct.
Okay, so I have, I do have some. I don't know what they are. I have 3 different links. I don't know which cases, if this is that case, but I'm going to look to try to figure it out. Did you send it, Mr. Kirker?
Yes, I believe I did.
Okay, I got something for Rashid Davis. I don't even know who that is.
That would be, I think that's this case. His middle name is Rashid.
Okay, so then I have it. I'll try to address it before the next court date.
Okay. What
So
about
I'm back to, I
February
just need a date, Judge. I need a date.
30th? How about the 28th?
No, Judge, that's pushing it. She's got 3 trials and we're doing them back to back to back.
Okay, so you need
That might be a little tight. So the 21st, and then if I'm out of. Can you give me, how about, do you have March 2nd available?
Yeah, March 2nd works.
What time, ma'am?
What's the earliest you can do? That would be ideal.
I can come there first and
Okay, you want to do 8:30 or 9?
8:30.
Wonderful. 8:30. think we're all set, right?
Yep,
All right, you have a good rest of your day.
you too. Stay warm, everyone.
Okay, you too. All right. Again. You're stuck with me. That's fine. So we can handle Brian first because that's gonna take about 5 minutes. That is the motion. Carl Grant. And sorry for asking here. You are Mr. Joshua
Jerome Thomas.
Thomas.
Yes, ma'am.
Okay. So I issued a KBS because you weren't here. A warrant. So I'll list the KBS since you are here.
Thank you so much.
You're welcome. You need to contact your attorney. Do you know who your new attorney is?
Oh, no, ma'am, I do not.
I'm gonna give you that information.
Thank you.
It'll be Attorney Riggins. Ken Riggins, he works with neighborhood defender. Do we have?
I have it, Judge.
Where's that? Okay, so we're gonna get the number. You call him because he was here, ready to go, okay?
Yes, ma'am.
And we'll have to set another date. We'll have him call in and give you another exam.
Yes, ma'am.
Probably next week. All right.
Okay, wait.
I just wanted to bring in the number to give it him.
Okay, let me just print it in here.
Mr. Bradford, do you have Mr. Riggins' number by any chance?
I can get it real quick, sure.
Okay. I like it, you all.
No, I mean like one of these.
So put the 15th at 9:00. Put exam date. And what we'll do is if Mr. Riggins can't do that date. just let him know. Keep print one out for the thing.
Oh, I bet it's a date.
We're on the record, this is people of the state of Michigan versus Carlos Bryant, 2258 470. Mr. Bryant is charged with 1 count of police officer assaulting, resisting, and obstructing. Today they set for preliminary examination. Appearances.
Alexander Griffin on behalf of the people, P86282.
Good morning, Judge, you and your staff. Cody Bradford with NDS Detroit, P85944 on behalf of Mr. Carlos Bryant.
Okay, and Mr. Bradford, I received a motion from you. I received it yesterday, and Ms. Parrish did receive it as well yesterday. Mr. Kirker, you did receive it as well, correct? Today?
Today.
Okay, all right, so I'm considering it a preliminary matter. We're not gonna hold this exam today. Based off of this motion that you provided, I want the people to respond in writing. I want you to reserve your argument until they provide in writing. I read through it and I think the best people have a response.
May I ask, Judge, since we're set for preliminary exam today, it's my understanding that neither of the arresting officers have appeared today. So even if Mr. Kirker would have had an argument and had time to respond, they could not proceed with the exam anyway. So I would ask that the case be dismissed.
So you want to remove your motion?
Yes, sure.
Okay, so you want to withdraw your motion
Yes.
and move forward with the exam?
Yes.
Okay. All right. Expect that one? Okay. That first, Mr. Kirker, both officers are present today.
I believe the OIC is here. It's my understanding the defendant is also not present.
Oh, the defendant is not present.
Correct, Judge. I haven't talked to him in probably over a week. He uses, text apps and things like that. I've tried multiple times today and have not been able to get in touch with him. I know it's unusual, but I would ask to waive his presence since the prosecutor cannot go forward, even if Mr. Bryant were here.
Yeah, that would be fair. Oh, he stepped to the mic to speak. So
sure.
So
All I said was that Mr. Bryant uses text apps and other texting apps that I've not been able to contact him in over a week. My request was to dismiss because even if Mr. Bryant were here, the prosecutor could not move forward with the exam because the two arresting officers are also not here.
okay, so I'm trying to be pretty fair. If your client was here and the police was not here, I would dismiss. If officers were here and your client was not here, I would case. We have a case where officer's not here and defendant's not here. The only thing I'm willing to do is adjourn this matter with the adjournment, unless both parties want the case dismissed. That's something I'm not sure if you all want to discuss or not. If that's not the case, if both parties don't want to mutually dismiss, have this case dismissed, then I'm going to adjourn it. And with an adjournment, you want to then have your motion heard.
Yes, Judge, could we take a couple minutes outside to speak? Or are you not inclined to this?
People are not inclined.
Okay.
Okay.
Then I would request the adjournment, Judge, and I would ask to reinstate my motion.
Okay. Second thing is, Mr. Kirker, I want Ms. Parrish here on the day of the adjournment because she's the one who responded to the initial request. So I want to give her 7 days to respond. So let me know after the 7 days, when's the next day that she's.
Judge, if I could just inform the court and the prosecutor, 7 days would put us till next week. I'm in trial from the 8th to the 10th.
Okay, how about I have the 15th.
That should work.
9 o'clock.
9, yes.
And Mr. Kirker, Ms. Parrish going to be here? The 15th, it'll be a Wednesday. The whole week?
I believe so.
know what, that'll just be. So how about 22nd?
That works for,
She's gonna be in court on the 23rd.
In here,
Yeah.
23rd. How about 23rd?
I could do the 23rd, Judge, but I have a motion hearing in another case at 9, so it would have to be after that.
Set it at 11 o'clock.
Okay, that works.
And how, and for the people, I should say, would it be Ms. Perry to respond in writing by the 14th? Okay, anything else?
That's all from the defense, Judge.
All right, I will see you all on the 23rd. Is there a motion? Leave or for.
Thank you, Judge. Great to you and your staff.
Thank you. Okay, we are on the record with the people versus Jacob Jamal Emmanuel Smith. Case 22600375. Mr. Smith is charged with count 6, weapons, firearms possession by a felon. Count 7, weapons, firearms possession by a felon. Count 9, weapons carrying concealed. Count 10, weapons carrying concealed. Count 13, weapons felony firearm. And count 14, weapons felony firearm. This is an habitual offender, fourth offense notice, and Mr. Smith is defendant number 2. They set for a preliminary examination appearances.
Alexander Kirk on behalf of the people, E86282.
Morning, Your Honor, Andrew DiMaggio, P45619, on behalf of Jacob Smith.
And I'm sorry, Mr. Biden, and you said what?
Who is in the court?
And Mr. Smith, can you state your name for the record, please?
Jacob Jamal, Jacob Smith.
Thank you. Good morning. Good morning.
Good morning, how you doing?
I'm fine. Okay, are we ready to proceed?
The people are not, Your Honor.
And in that case, Your Honor, we would make a motion to dismiss.
Okay. Time is now 11:20. The preliminary exam was scheduled for 10:30. The people are not ready to proceed, so I will dismiss without questions. So you take your business.
All right. I gotta fill out that form, or we do it different here. Does it just this one? Yeah. Oh. Judge, off the record, can I show you something cool?
Yeah.
This is my grandpa with Joe to my
Okay, we're on the record with the people of the state of Michigan versus Sanad Abdel Ahmed Al Harami, with defendant number 1, and Ishaq Sal Al Harami, with defendant number 2. This is case 2259445. Defendant 1 is charged with count 1, assault with intent to murder. Defendants 1 and 2 charged with count 2, assault with a dangerous weapon, felonious assault. Defendant 1 charged with weapons, felony firearm. And defendants 1 and 2 charged with count 4, weapons, felony firearm. Today is the day set for a preliminary examination. Appearances.
Good morning, Your Honor. Laura Intercession, Count the People, P67104.
And good morning, Your Honor. Good morning to your staff. May it please the most honorable court. Mohammed Nasser, P74485, appearing on behalf of this and with Mr. Sanad Al Harami, who appears standing behind me. Sir, please state your full name for the record.
Sanad Al Harami. And good morning, Your Honor. Good morning to your staff. Edward Martel, P85051, on behalf of Ishaq Al Harami, who stands to my rear. Sir, please state your full and complete name for the record.
Good morning, Your Honor. Sabree, Deputy Area.
And Ms. Rob, I'm gonna swear you in. You swear to translate Arabic to English and English to every rest of your ability.
I do.
Okay. And state your name one more time for the record.
Sabree, Rahmal, interpreting Arabic for the court.
Okay. Okay. No. Okay. The court reporter still didn't get your.
Oh,
it's kind of hard to hear.
I say, just 22 years here. I say ERAH. The last name is Drake, RAH.
And can you state your name for the record? And are all parties ready to proceed?
Yes, Your Honor.
As is defense judge.
Yes, Judge.
So with the interpreter, I'm going to pause.
Okay.
To give a moment so that you can relay anything or everything. Okay.
Okay.
I know he's not going to speak for most of the, or probably none of the exam, but I will, if you want to go on delay, it's just so that the interpreter can tell me.
The people will be cognizant of that as we're asking questions and waiting for answers.
Do you have any preliminary matters?
Yes, Your Honor. The people would request that our officer in charge, Officer Alexander Gunther, remain in the courtroom.
Any objection?
No, Judge.
No, Judge.
Okay.
Other than that, Your Honor, we would ask for mutual order sequestration, but we believe there is no one else in this courtroom.
Okay, that's correct. No one other than the attorney, the staff, and the interpreter, and OIC are present. So with that, you call your first witness.
Thank you. At this time, the people would like to call Ganellaro Simpson. I will spell that because I'm sure I said it incorrectly. It's GLENNELLRO. Simpson, common spell.
Your Honor. Happy to like come in. Okay.
Before she comes in, goes to the court first, and then come to me and I'll swear you in.
Right here is good.
Who's that?
He's the advocate.
Give me 1 second. Back in the court. Back in the hallway. Let's tell the truth, and nothing but the truth.
Yes, ma'am.
Have a seat. Make sure you speak into the microphone.
Yes, ma'am.
Before you get started, my name is victim advocate one for coming to the courtroom. Does the defense counsel have an objection to the victim advocate in the courtroom?
None, Judge. Thank you.
None on behalf of the defendant.
Thank you, Judge. And one more thing, after yesterday's code two defendant case. Madam Court Reporter, do you need defense counsel to state their name on the record when they begin speaking to the mic? Because we've had issues with the mask and who's talking. So if you could be cognizant of that as well.
Thank you, Judge. Mr. Simpson, can I have you state your name for the record?
Glenn Wesley Simpson.
Okay, thank you. And Mr. Simpson, I'm going to take you back to the date of August 31st, 2022. Did something happen that date that brings you to court?
Yes, ma'am.
Okay. And did you receive a phone call from anyone on that date?
Yes, ma'am.
Who was that?
Aisha Harrell, mother, kid's mother.
Aisha Durrell?
Harrell.
Harrell, okay. And around what time of day did you receive that phone call?
Probably like 10, 20, 10, 10-ish.
Okay. Would that be in the AM or PM, sir?
AM.
All right. And did she alert you to a location?
Yes, ma'am.
All right. And did you go to that location?
Yes, ma'am.
All right. What was that location?
Gas station, Shell Pump.
Okay. And that location, that Sunoco gas station, is that at, give me one moment.
Judge, we stipulate to the location.
And just so the record reflects, 15111 Houston, Whittier Street in the city of Detroit, County of Wayne.
Yes, ma'am.
All right, is this a gas station you've been to prior?
Yes, ma'am.
All right, prior to that date of August 31st.
Yes.
Okay, and were you, can you tell me the nature of why you went to the gas station?
The day of the event,
Yes.
my kid's mother had called me and told me she was.
Your Honor, I'm going to object to anything the kid's mother may have told me.
I'm not offering it for the truth of the matter asserted, Your Honor. I'm offering it for this witness's state of mind.
You said the witness to do what?
I'm not offering for the truth of the matter asserted. I'm offering for this witness's state of mind.
The last part I can't understand. State what?
The state of mind.
State of mind.
Right, for why he went there.
That would be relevant. We have for the truth of the matter asserted, or we have why he was alerted to come to the gas station.
Correct.
So I'm going to sustain that based off of, unless you have an exception.
Well, I'm not offering it for the truth of the matter asserted, Your Honor.
But you're offering it for his state of the complaining witness's state of mind.
Right.
For what?
For why he went to the location. The reason he's going to state why the mother of his children called him to go there. So I'm offering it for that purpose, not for the purpose of the truth of that statement she gives him.
Okay, so you rephrase the question and saying, based on conversation from that person, how did you feel?
Sure. Okay.
Thank you, Judge.
When you spoke to, can I get her name again, sir?
Aisha Harrell.
Harrell, Ms. Harrell. When you spoke to Ms. Harrell, did she place you on FaceTime or was it only on phone? Was it on speakerphone? Okay. And when she was on speakerphone, could you hear just her voice or someone else's voice?
I heard her arguing with the male.
All right.
She was telling me that this person was locking her in and wouldn't let her out.
All right. And because of that information, is that why you went to the gas station?
Yes, ma'am.
All right. When you went to the gas station, did you see Ms. Harrell there?
Yes.
All right. Did you see a male interacting with her?
Yes.
Did you see her vehicle?
Yes.
Can you tell me what was it about her vehicle?
She had a slow leak and she was going there to receive air.
Okay. And did you see a person arguing with her?
Yes.
Do you see that person in the courtroom
Yes, I
today?
did.
Okay. Can you tell me where that person is seated and what that person is wearing?
He had a blue shirt with the headphones around his ear behind.
Thank you. Let the record reflect that the witness has identified Mr. Sanad Al-Halami. Thank you. All right, and did you hear what the defendant number one was saying to the Terrell?
Bunch of cursing back and forth, arguing with it.
Okay, and so what did you do when you saw that?
Once I got there, I walked up on him, I was angry because he was arguing with my lady. I started fighting
Okay, all right, and were you fighting with him outside?
outside and we, fell on the inside of his, gas station.
All right,
Of the gas station.
have you seen this defendant, Sanad Abdul Ahmed Al-Halami before?
Yes, I have.
All right, is this someone that you saw regularly when you went to that gas station?
Normally when I go to the gas station, they bring it.
Okay, so you're familiar with this individual? All right, and so is it fair to say that you two were physically fighting?
Yes.
All right, did something happen while you were physically fighting?
He, said some foreign language, I don't understand what he was saying, and someone passed him a weapon.
All right.
And I took off running.
Okay, so I'm gonna back up a bit. So you said, so were you two actively physically fighting each other at this time?
Yes.
All right.
We was into it, yes.
Okay, and you say that he said something in a foreign language?
Yes, ma'am.
All right, did you see who he was speaking to when he was using that foreign language?
Gentleman behind me with the dark blue shirt on.
Let the record reflect that the witness has identified defendant number two as Sheksel Al-Alhami. So reflected. Okay, when he said those words in a different language to defendant number two, what did defendant number two do?
Passed him a weapon, passed him a gun, and I seen it, I took off running.
Okay, and where was defendant number two when defendant number one spoke to him?
Behind the glass, like, we were outside the store, he was inside the store behind the glass.
Okay,
Working, I guess.
would he have been behind the cash register?
Yes.
That portion of the store?
Yes, ma'am.
Okay, and did you see how he handed the a weapon to defendant number one?
Through the way you get your food, you give it to you through the counter thing.
Is there a turntable that separates, is there a turntable that separates the inner portion, the employee portion of the store and the customer portion?
Say it again.
Is there a turntable area where someone is passed something from the employee section of the store and the customer section of the store?
Yes.
Okay, is that where defendant number two passed a weapon to defendant number one?
Yes, ma'am.
What type of weapon was it that defendant number two passed to defendant number one?
Kind of hand.
Okay, did you say kind of handgun?
Handgun, yes, ma'am.
Okay. And did you see what defendant number one did with that handgun once he?
I had took off running already.
Okay, did you see him get the handgun?
Yes.
Okay, what did he do with the handgun?
Once I took off running, I didn't see nothing else, all I heard was shots.
Okay, and when you heard shots, where did you hear the shots coming from? Do you know?
From my belief.
Objection, that's speculation as to where you believe.
That's fair, Your Honor, I'll reword the question. Okay. When you heard shots, where were you?
Running, from the gas station, trying to take cover from the shots. I was
Okay.
running like towards the gas station, I was running towards William.
Okay, and did you see anyone chasing after you?
Couldn't see him, my back was turned, but I knew it was, because once I ran for cover and I ran to another store, from his store, and then the defendant who I had a fight with was on me with a gun.
Okay.
He had the gun on him.
Let
On
me,
him.
all right, so defendant number one, and once you took cover at another store, you saw defendant number one with that gun?
Yes, he chased me from the gas station to the store.
Okay, did he say anything to you?
He said, I should kill you for me and him having a fight.
Okay,
And I told him he had already wounded me.
all right, have you been wounded?
Yes, ma'am.
When were you wounded?
While I was running.
Okay, and those shots that you heard, were they immediately, can you tell me when you heard those shots?
It took probably like no more than 5-10 seconds of me running.
Okay, so about 5-10 seconds from you starting to run away towards?
Yes, I wasn't even out of the gas station. I was like leaving out the gas station parking lot, running on foot.
Okay.
Yeah.
And once you observed defendant number one with that gun, did he shoot again?
He shot more than once.
He shot more than once?
Yes, he shot multiple times.
All right. And where were you shot, sir?
In my foot, my right foot.
In your right foot? Okay. Can I have a moment, Your Honor? All right, sir, when you went to hide, can you tell me where you were hiding?
I just ran in the store and asked the store owner could I come behind and found somebody was trying to kill.
Okay.
He said he couldn't do that.
Objection as to what the store.
That's fine. So you asked the store owner if you could go hide behind the counter?
He wouldn't let me.
Okay, what did you do?
I was just stuck, like nowhere to go, because the defendant was right there with me.
Okay, let me ask you, let me back up because it wasn't clear. So you said the defendant was right there behind you?
Yes, ma'am.
All right, what kind of store was this that you ran
A
into?
liquor store.
A liquor store. And how far was this liquor store from the gas station?
Like close to a block away.
Okay, and so defendant number one followed you a block away to this liquor store?
Yes.
Okay, were you inside the liquor store when the defendant came into the liquor store?
Yes, ma'am.
All right, did the defendant still have that gun on him?
Yes, ma'am.
What was he doing with that gun?
Pointing it back and forth as he was trying to get me to leave. He was saying, call the police, so he wanted to, but the person actually said he wanted to kill me. I was just scared. I just had my hands up and then I could do.
Let the record reflect that the witness had both hands up, palms facing out. Sir, thank you. And sir, is that what you did when the defendant had that gun at you, pointed at you?
Yes, ma'am.
Okay. Thank you. I have no further questions, Your Honor. However, the people will move to add a count of assault with intent to murder for defendant number two under the aiding and abetting theory, and a corresponding felony firearm for that assault with intent to murder for defendant number two. We now turn it over to defense for a cross.
May it please the court? Thank you. Mohammed Nazar, Madam Court Reporter. Good morning, sir. Good. Sir, I'm gonna ask you some questions. If you don't understand, please let me know and I'll try to rephrase it in a way that you can understand. Is that fair?
Sure.
Okay, you've already testified that there was an incident that occurred on or about August 31st of last year, correct?
Yes, ma'am. Yes, sir.
And it's your testimony here today that your child's mother was at a particular gas station, agreed?
Yes, sir.
And it's from your understanding that she was at this particular gas station to get some air in her tire, is that correct?
Yes, sir.
Okay, do you live in this particular area where this gas station is,
I
sir?
stay there, yes, in that area.
You do?
Back and forth, yes.
Okay, so you're fully aware of the fact that there was no power in that area at the time, right?
I have no idea. I was at home.
Okay, did you have power at your home?
Yes, I did.
Objection not relevant.
Absolutely relevant, Judge. It has to do with the mindset of what's going on at a store when the power is out in the light, and he said he lives in the area, so if he knows it, he knows it. If he
My
doesn't,
power
he
was
doesn't.
on. Oh.
It's close for speculation and it's not relevant. It's assuming facts, not evidence, it's close for speculation, and it's not relevant whether or not the witnesses or the girlfriend's home had power. I don't believe it's relevant whether or not Mr. Simpson's big or mother, his child had power. Based on what you're
Duly noted. So it's your testimony here today that you're unaware of the fact that this gas station didn't have power?
I did have no idea that gas didn't have power.
Okay, so your girlfriend didn't advise you that the air machine didn't work because there was no power?
Objection.
No, she did
What's
not.
the objection? 1 second. Okay, I withdraw the objection.
The answer is no, she didn't? The answer is no, she did not?
Answer the question again.
Your girlfriend or your child's mother, forgive me, didn't advise you that the air machine did not work because there was no power at this gas station?
No, she advised me that she would have a problem with the mail.
Okay, and so it's your testimony that you had some type of telephonic conversation with your child's mother, correct?
No, she called me.
Yeah, so forgive me, I'll clear it up. She called you on the phone, right? And she told you that there's some incident going on
Yes.
with an individual at the gas station, right?
Yes.
your girlfriend had been at this gas station before as well, correct?
Yes.
Okay, and through the questioning of fine sister counsel here, my client is somebody that you've seen before, right?
Yeah, I have been to a store before.
Okay, and you recognize this individual as being the owner of this gas station,
I
right?
don't know if he owns it, but I recognize it.
Okay, you recognize him as being at this store previously, correct? Okay, and you testified candidly that you were kind of pissed off that this guy's fighting or arguing with your child's mother, right?
Yes.
And so much so that you make it to this gas station in short order, quickly, right?
That was very.
How long?
5 minutes. 5 minutes.
And during this entire period of time, you're on the phone with your child's mother.
She said she couldn't get up. No, it was not the entire time on the phone with her, no.
Okay, so when you were having some discussion with your child's mother, it was on a phone call, right?
Yes.
And did that phone call eventually change into a FaceTime?
I can't remember.
Okay, however, when you arrived at this gas station, where were you located when you got this phone call?
When I received the phone call that she was having a problem, I was at home.
Okay, so, and did you drive over, walk over, what did
I
you
got
do?
to ride. I was walking, then I got a ride by a gentleman that I seen walk, was headed out.
Okay, so some person drove you to the gas
Yes,
station?
sir.
Okay, now, was your child's mother alone or was she with
No,
some
she was
people?
with all 2 of my children, her oldest daughter, and 2 of my grandchildren.
Okay, and how old is the oldest daughter?
Objection relevant.
And we were identifying as grandchildren, minors, okay.
Yeah, yeah.
I don't see the relevance to what they're including in the story.
Which one, Judge? I'll move on. Okay, however, you're angry when you get here, right?
Yes, I was.
And you immediately approach this clerk, correct?
Yes, sir.
And it's true that you punched him right in the face, right?
Yes, sir.
Okay, and when you punched him, he dropped to the ground, right?
Yes.
And then you got on top of him, right?
No, sir.
You never got on top of him?
Because he was already reaching for the gun. I was running.
Okay, so you punched him, he dropped to the ground.
Yes.
So out this physical exchange, you certainly got the best of this guy, right?
We was fighting.
Okay, but he's on the ground with a punch that you just threw, right?
We were fighting.
Okay, so you just testified seconds ago that you punched him in the face and he dropped, right?
We were fighting.
I understand that, but listen to the question. You just let me finish.
Yes, sir.
You just testified seconds ago that you arrived, punched him to the face, and he dropped, right?
Yes.
Okay, and at that point in time, that's when you heard him say, in the language that you don't understand, right?
Yes, sir.
Okay, so, and how far is the counter, sir, from where my client is lying on the ground being knocked out?
Right there, his head was right there.
Okay,
We
so,
was inside the store.
okay, so
So it's real small. It's real small. Once you fall in the store, you at the counter.
would you say it's the distance between you and I or closer?
So what are you asking me?
I'm
For
saying, Judge, may I walk in front? Sure. Thank you. Forgive me. So, and forgive me about that, sir. Forgive me for that. So I would say the distance between you and I are approximately about 5 to 6.
I think, when it was going on so fast, so heated, once I hit him, he fell in the store.
Okay, so he fell into the store, right?
We did, he tried to swing backwards, but what I'm saying is, he was in the store and he said something I couldn't understand, and I seen that guy there pass him.
Okay, so when he fell into the store, would you say that his head was closest to the counter?
Yes, most definitely.
His head was closest to the counter, right?
Yeah.
So, but his head, meaning he was on his back, correct?
I don't know.
Okay, was he, but you guys were facing one another, right?
He was trying to get up, sir.
Okay, he was trying to get up.
Yes, he was getting up.
Okay. And at this period of time, it's your testimony that you heard him say something, correct?
Exactly.
And you don't speak Arabic or whatever language it was, right?
No, sir.
So you don't know what was said and what was said, correct?
I do not.
Okay, however, it's your testimony here today that while my client is on the ground, he says to him in some language, something, right?
Exactly.
Okay, and at that period of time, that's when it's your testimony that you see some type of object being passed on?
From that guy there, yes, sir.
This fine gentleman
Yes, sir.
over here.
Yes, sir.
Okay,
And
and at
for
that,
the record, that would be been due.
Yes, sir. Yes, ma'am.
my apologies, Judge. Thank you so
Want to
much.
make sure for the record.
Okay, and that, when you see that object being passed, that's when you take off, right?
Yes, sir.
And you take off running, agree?
Yes, sir.
And so in order to take off running, you have to kind of like turn your back and run, right?
Yes, sir.
Okay, and you're running fast, right?
Yeah.
And it's your testimony here today that you hear couple of shots being fired, right?
Numerous.
I'm sorry?
More than a couple.
Okay, so you know how many shots, sir?
I think more than 4, maybe 5.
More than 4, maybe 5 or so? Okay, and when the time prosecutor is asking you some questions, you're running, you're not looking back, right?
I'm running.
You're running, and you're running straight forward to whatever.
I'm zigzagging. I'm trying to dodge this man from trying to kill me.
Okay, so you're running and zigzagging, right?
Yes.
Okay, and you know, the zigzagging isn't something that's written in the statement that you offered to the police, is it?
I was running.
Okay, so you're running, right?
Yes.
And when you testified to the prosecutor, you said, hey, listen, I'm not looking back, I'm running forward, right?
Yeah.
So you don't know who was shooting the gun at that time, do you?
Yes.
You do know?
Yes.
So
the guy who ran up on me with the gun in his hand at the store.
okay, but you never actually saw him shooting, correct?
I got hit with the bullet, sir.
There's a distinction from what I'm asking. I understand when I tell you a
Yes,
story
yes,
and you're
yes,
gonna get
yes.
that opportunity. The
I
question,
heard him saying he was gonna kill me.
you heard him inside of the store,
No,
right?
when he was chasing me, sir.
He's saying something as he's
He's chasing me and saying, I'm gonna kill you.
Okay.
Don't run, stop. He's trying to make me stop, sir.
Okay, so that's not in your report either, is it? Right?
Tell the police
So
what
as
it
you're
is.
telling the story, it's getting a little bit more involved, right?
Objection argumentative.
Oh, which one? Okay, so you're adding some facts here that weren't in your report, correct? So I'm gonna ask you again, it's a simple question.
Yes, sir.
Did you actually see
I
my
didn't
client?
see
Let me-
him.
let me-
I was running. I didn't see him shoot at me. No.
You didn't see it, okay, thank you. However, at some period of time, you get into the store, right?
Yes.
And the distance is about a block, you said? It's across the street, is that fair?
Yeah, close to a block, yeah.
Okay, and you said you were shot at the bottom of your foot?
Yes.
And it was the right foot, agree?
Yes.
And you would agree that the right foot is closest to the ground, correct? Your foot, you're running with your feet, right?
Yes.
So you were shot at, and I apologize, forgive me for that. Were you shot on the right foot? Was it at the back? Was it at the side? Was it at the bottom? The back of your foot.
Yeah.
However, you were still able to continue running, right?
Yes, my adrenaline was running. I was trying to most definitely not get hit again.
Okay. And you got into the store, right?
Yes.
Was there other people in the store?
The store owner, I can't really remember, but I do remember that some pictures came in with it.
I'm sorry?
Some people came in with him, behind him, chasing me.
Okay.
Other people came in behind him.
Okay.
So it was other people in the store after he came in.
Okay, but there weren't other people when you
I
originally got
can't
in?
remember.
That's fair. So you go in and there is some gentleman behind the counter, right?
Yes, sir.
And you said, hey, help me, right?
Yes, sir.
Okay, and that's when it's your testimony that my client enters the store, right?
Yes, right behind me.
Okay, and at this point in time, you put your hands up, right? I'm sorry?
Yes, sir.
Okay, but you are standing, correct?
Yes, sir.
Okay, you are walking away.
I'm standing on the toe of my heel trying to show him you already been hit me, sir.
Okay.
Please don't kill.
Okay.
My hands.
Your hands are up, right?
Yes.
And he's angry because you punched him in the face, right?
Yes.
Okay, and at that point in time, and I think, and again, I believe the prime prosecutor asked me this, forgive me, I don't mean to be redundant. He says something along the lines of, he's calling the cops, right?
Excuse me.
The gentleman with the firearms tells you he's gonna call the cops, correct?
You come out the store, you go over me, taking me to the police, and we're gonna call the police. I said, no, I'm not leaving.
Okay, that's fair, that's fair. And at some period of time, the police do arrive, right?
Once we get outside, once the same police come, yes, outside.
Okay. Okay, and it's fair to say that you didn't call the police, correct?
No.
Okay. Did you remain on the scene to offer the police a statement?
Yes.
Okay, ultimately, you left this particular location at some period of time, right?
I'm misunderstanding.
Yeah, you know what's a bad question, forgive me for that. I'm saying, you stayed on scene to talk to the cops, right?
Yes.
And then after you finished talking to the cops, ultimately, you left on your own, or did you leave with somebody else?
I left and went to the hospital, sir.
Okay, what hospital did you go to?
I went to St. John.
St. John's. Were you admitted, or did you stay the night?
I got seen and was released.
The same day?
Yes.
Okay, and again, forgive me, I think the prosecutor already asked, it's summer, right? It's August 31st.
Yeah.
So it's bright outside when this incident is taking place, right?
Yes.
the one shot that did take effect hit the back of your right foot, correct?
Yes.
In the past 10 years, have you been convicted of a crime of theft or dishonesty, sir?
Excuse me?
In the past 10 years, have you been convicted of a crime of theft or dishonesty, sir?
In the last 10 years?
Yes, sir.
I've been convicted of a crime or what?
Theft or dishonesty?
No. I haven't been.
Objection. I'm just gonna ask the witness not make any other statements. There's no question on the floor.
And I would concur with that. Thank you so much. How long was the police on scene, if you know?
I have no idea.
Okay. When you originally arrived on scene, did you see that my client, and when I say my client, defendant number one, did you see that he was holding a phone?
Yes, he was recording and still talking, cursing with the lady.
Okay, so he was recording, right?
Yeah, I don't know what he was doing. He had his phone like he was doing something with it, as far as whatever he was doing with his phone.
Okay, perfect. All right. And when you arrived, he was still recording, right?
Yes.
Thank you so much. No further questions, Judge. I thank you, son.
Yes, that's what he was doing.
Your Honor, if I may?
Yes.
Thank you. And for the court reporter, Edward Martel, P 85051, on behalf of the defendant. Mr. Simpson, how are you today? All right, okay, so I'll be brief. If there's anything you don't understand, please let me know and I'll try to rephrase, okay? Okay, so again, we're gonna take you back to August 31st, 2022, okay? And again, you stated that you testified previously, you were in the area of Houston, Whittier at the Sunoco gas station, correct?
Yes.
Okay, you were called there by your child's mother, Aisha Harrell, that's correct?
Yes.
And again, prior to arriving there were some conversations which you overheard on her, when you were on the telephone, correct?
Yes.
Okay, and upon arriving, obviously you encountered an individual with with a phone pointing at you, et cetera, whom you identified to be defendant number one, correct?
Yes.
Okay, now, at no point in time, when you arrived, let me retract that. When you arrived, my client, defendant number two, was behind the counter at that time, correct? Okay, and at some point in time, again, you said you were angry when you entered the building, correct?
We fought from outside to inside.
So you fought from the outside to the inside, is that during that whole period of time?
Upset about being my wife, my kid's mother being.
Understood. During that complete period of time, my client remained behind the counter, correct?
Correct.
Okay, at no point in time did my client come behind that counter, correct?
I was.
You never seen him come behind the counter?
Objection. Time, please. Okay.
Let me, if I may rephrase, Judge.
Actually, yes.
Thank you.
For
And forgive me, Madam Clerk, Lord. You made a statement to the police regarding this complete incident, yes?
Yes.
Okay, at no point in time did you identify within that statement or state to the police that my client came from behind that counter, fair?
No.
Okay, because you never seen him come from behind that counter, did you? Okay, in fact, you've never had no issues with my client, present or previous, have you?
No.
Okay, and in fact, at some point in time, you indicated that there were some words exchanged between the owner and the employee, my client, yes?
Sure.
Okay, and then at some point in time, you indicated that my client put something within the turntable, yes? After that, you indicated that you took off running, right? For lack of better words, you were ghost, yes?
I was running, sir.
Okay, running for your life.
Yes.
Okay, so that was the last you seen of my client, fair? You didn't see my client in no time after that, fair?
No, not until when they got.
I'm sorry, okay, at a later time when the police arrested, okay? And obviously, my client, you did never fire no shots at you, yes?
No.
My client never said anything aggressive to you, yes? Nothing. No further questions, Judge. Thank you.
I just want to clarify the physical fight you had with defendant number one.
Yes.
So the physical fight began outside the gas station?
Yes, like he was standing like in the doorway.
All right.
He was standing right in front, like this, the door, he was standing here.
Let the record reflect that the witness is pointing to the doorway of the witness cubicle. So, and so would it be fair to say that defendant number one was almost touching the door of the inside
He
of
was
the store?
standing right in the doorway outside, talking, the baby was on the side of the gas station, he was outside communicating with him, like this.
Okay. All right. So the physical fight began outside.
Yes.
Did the defendant number one strike you
He
while you were
tried to grab-
outside?
He tried to grab me, but I was upset, I was trying.
Okay. And so would it be fair to say he was fighting back?
Yes.
Objection, Your Honor, that would call for speculation as to whether or not somebody's caught fighting back or not.
I think the witness just described it as fighting back.
Yes.
And it's a yes or no question.
An individual trying to defend it.
Mr. Simpson believes it's fighting back.
Okay, that's fair, Judge. Withdrawn. Thank you so much.
And and the fight continued, were you two struggling when you entered into the inside portion of the gas station?
Like, I hit him and he was trying to grab me, he fell, he had said something, I ran.
Okay.
Once I seen the, the interaction of what they were doing.
Okay. And and I just want to clarify, you said in the action of what they were doing, are you referring to defendant number one speaking to defendant number two?
Yes, ma'am.
All right. And so I have nothing further as to that. I have nothing further, Your Honor.
Nothing further, no.
Nothing on behalf of defendant.
Cross, rather. Okay. Thank you, sir.
No further questions.
Okay, Mr. Simpson, you can step down and have a seat in the hallway, okay? People have any other witnesses?
No, Your Honor, people do not have any other witnesses. We will move to bind over on all four counts, including the added counts of assault with intent to murder and felony firearm for defendant number two, under the aiding and abetting theory. We will argue that Mr. Simpson came to the location believing he was defending the mother of his children, who was being yelled at and had in an altercation with defendant number one. He came upon defendant number one, and yes, he admittedly, they got into a physical altercation. Mr. Simpson indicates that he was struggling with him and that the defendant number one was fighting back, that he was trying to push him away and fighting back, and then was punched by Mr. Simpson and fell to the ground and in the course of that physical altercation asked defendant number two for his gun, or what we can only assume is for his gun. Because upon saying something to defendant number two in a language that Mr. Simpson stated that he did not know, defendant number two did pass to him a handgun. But for defendant number two handing that gun to defendant number one would have been unarmed. Defendant number one, there is that saying, you don't bring a gun to a fist fight or a knife to a fist fight. Well, that's exactly what this defendant and defendants did. They escalated a physical situation into a deadly situation. There is even if they were to argue self-defense does not mean that they can raise the risk and elevate it to a fatal situation when only fists are being used. The defendant number one was conscious, was lucid, and was fighting back. This was not a sucker punch. This was a fight amongst two men, a physical fight amongst two men. Defendant number one looked to defendant two for assistance and received that assistance by way of receiving his handgun from defendant number two, who then chased after Mr. Simpson. Mr. Simpson testified that it was about 5 seconds after he started running that he heard the gunshot. He heard numerous gunshots. in fact, was struck by a gunshot. And defendant number one even chased him down 1 block away from the point at which they had their initial altercation, and still had his gun at him and pointed at him with that gun again. The witness even states that, I wrote it down. I'm going to kill you. The witness stated that defendant number one said, I'm going to kill you. He made his intent clear. And Your Honor, if defense even does argue self-defense, the defendant defendant number one chose to follow him 1 block away from the point of danger, and the danger had been alleviated at the point that the witness had left the location. In fact, there was no danger. There was no deadly danger to the defendant number one or defendant number two, which would negate the use of a lethal weapon. So for these reasons, we ask for the bind over on the additional charges and the bind over on the charges that are already on the record.
May it please the court, Judge? Mohammed Nasser, closing remarks on behalf of the Senate. First and foremost, Sister Counsel has done a phenomenal job as always. I applaud her efforts and I applaud the efforts of the people. But Judge, this court has had the opportunity to hear the fine testimony of Mr. Simpson. What Mr. Simpson said upon my cross is very simple, that his child's mother is at a gas station, that she engages in some type of argument, discussion with an individual. He's angry. He's so angry that he runs over, gets a ride, and comes over. Upon cross, he says with specificity, I walked up and punched him in the face. This man drops. He's on the ground. So there is no altercation or fight, Judge, if somebody's punched in the face and knocked. Not only is he knocked, he's knocked from the outside of the store to the inside of the store, that his head drops back and the counter's behind him. That's what his fight is. That's what it is. Punching a guy out because he's pissed off that he has some coarse words or words for his child's mother. That's what the testimony is. Now, the variance is that now, then there's some exchange of words that is offered by my client to Mr. Ishaq al-Halami. The complainant runs off quickly. His testimony, Judge, what I want this court to focus on is this. His testimony is he saw an object. He then, as soon as that object is being put within the window, he takes off. He's not looking back. He's running zigzags or whatever have you across the street to the liquor store to the other location. He doesn't know who's shooting him at all. He hears 4 to 6 shots, or at least 4, maybe 5 shots. He purports that one shot takes effect on the back of his right foot. Doesn't stop him from continuing to run the significant distance that the sister counsel has most aptly stated in her fine closing argument. That it's a significant distance, Judge. It's a block at least. That he is able to continue running. Adrenaline is running through. He doesn't drop. A shot to the bottom of the back of the right foot is not assault with intent to do great bodily harm less than murder. It is not. In order to prove assault with intent to do great bodily harm less than murder, first element pursuant to the criminal jury instructions. First, the defendant tried to physically injure another person. 2, that when the defendant committed the assault, he or she had the ability to cause an injury, or at least believe he had the ability to cause an injury. And 3, that the defendant intended to kill the person. Right? So again, Judge, 1, an assault. 2, with an actual intent to kill, which if successful would be a murder, which is People v. Brown, which is 267 Mishap 141, which is a 2005 case. However, an intent to kill for purposes of assault with intent to murder may not be proven by the intent to inflict great bodily harm or a wanton and willful disregard of the likelihood that natural tendency of the acts will likely cause death or great bodily harm. Again, that is People v. Brown, 267, Mish Act 141. That's a 2005 case. What you have here, Judge, is undeniably an individual that exercised extremely poor judgment. Agreed. Myself and the fine prosecutor are not going to disagree about that. But what we disagree wholeheartedly is that there is no assault with intent to murder. He says he walked into the store. He says, I want to kill you. He didn't shoot. He didn't do anything inside of that store. If he wanted to kill him, if he wanted to shoot him, he would have. That would satisfy. And I would agree, and we wouldn't be arguing here right now if he was solely charged with assault, felonious assault, which is count number 2. That is the true charge here, Judge. That is the true charge. He got a minor shot to the bottom right of his foot, so much so that he stayed for a period of time to talk to the cops. He then drove himself. He didn't get into an ambulance. He drove himself to the hospital, St. John's, and was released the same day. That is not assault with intent to murder. It is not. So as it relates to count 1 and the accompanying felony firearm, Judge, I'm asking this court to dismiss. I would agree that by the testimony that has been offered here today, that the people have met their burden. Over my objection, of course, but the people have met their burden as it relates to felonious assault and the accompanying felony firearm that's associated therewith. But they have not met that burden of assault with intent to murder. And in light of that, Judge, I'm begging this court to dismiss those counts.
Your Honor, may I respond to defendant? I was going to ask if you wanted to wait or respond as defense counsel. I would rather respond immediately. Okay. Because I received different issues. So, Your Honor, I admire defense counsel's passion. However, he negates the fact that the defendant shot multiple times. That in of itself indicates the defendant's intent. You don't get points and get a dismissal of a count just because you're a bad shot or shooting at a moving target. The victim indicates he was running. He's running for his life. He runs to the liquor store, and all the while he's being shot at. The defendant's actions are absolutely clear when he asks for the gun, gets the gun, and follows the witness, Mr. Simpson, away from the defendant's store, away from the point where he's ever even in some sort of physical harm. The witness has now left, and the defendant is still running after him, shooting multiple times, and then follows him a block into the liquor store. A liquor store that's not his store, not a point of safety for this witness, and says, I should have killed you or should kill you. The defendant displayed his intent. He did so when he followed the witness, Mr. Simpson, from his store to this liquor store, shooting him along the way. Just because the witness was not gravely injured does not mean it does not rise to the level of assault with intent to murder. Again, the injury is not an element of assault with intent to murder. The intent is the defendant's actions, and the defendant's actions are shooting the witness multiple times, even after a point of any physical harm no longer exists.
Judge, if I may, thank you. First and foremost, Judge, let me say, Sister Counsel did a fine job. And we would also, on behalf of defendant number 2, join in defendant number 1's arguments regarding the added counts, AWIN and felony firearm, Judge. And Judge, let me start off by saying, pursuant to People v. Johnson, 407, Mich. 196 to 1979 case, felonious assault is a specific intent crime. As this honorable court is aware, assault with intent to murder is also a specific intent crime, Judge. And pursuant to People v. King, Judge, there must be some scintilla of evidence as to each element of the charged offense sufficient enough to bind over to a probable cause standard. In this particular case, Judge, there's no intent, right? Aiding and abetting theory, which is the overarching issue for my client. First and foremost, the alleged crime must have been committed either by the defendant or someone else. B, second, that before during the offense, the defendant did something to assist. And C, which is the missing element here, that it must be present, or the bind over cannot be, cannot be bound over. The defendant must have intended the commission of the crime alleged, or must have known that the other person intended to commission, and that it was a natural and probable consequence of the commission of the crime intended. In this particular case, Judge, we heard the testimony. There was no prior animosity between my client and Mr. Simpson. My client never came out from behind the counter. My client never raised his voice. There was never anything from my client to suggest that he intended for any crime to result. In fact, there was in my cross-examination, there was the testimony that of the defendant number one was the owner and my client was the employee. So I would further argue that an agency, there cannot be a aiding and abetting when there's an agency relationship, Judge. It cannot be, Judge. And based upon saying, Judge, I'm asking this honorable court to dismiss all counts. My client never even handed him something physically. In fact, there wasn't even a clarity as to what there was the alleged item was that was handed. It was something placed within the turntable. Again, but the overarching issue here, Judge, number one, there's a missing element, intent. It wasn't a natural consequence, certainly. And last and most importantly, there's an agency relationship. And for those reasons, Judge, I would ask this honorable court to not bind over on all counts. Thank you.
And if I may, Your Honor, the witness specifically stated it was a handgun shot. Why he ran away? And defendant number one would not have had that handgun had defendant number two not given it to him. So to say that he didn't intend for any crime to result doesn't make sense considering his actions of handing a gun to defendant number one. The defendant number two's aiding and abetting assisted in defendant number one's actions against Mr. Simpson.
Okay, the court has heard testimony from Mr. Lanelro Simpson, who stated that he received a call from his child's mother, Ms. Aisha Harrell, around 10:30 a.m. It alerted him to the Sunoco gas station at 15111 Houston Whittier in the city of Detroit on August 31st of 2022. While on the phone, he heard Ms. Harrell arguing with a male that a person was blocking her in and about slowly and trying to get air. And when Mr. Simpson arrived, he said he got a ride while he was walking on his way there from someone he knew and saw the defendant number one arguing with Ms. Harrell, and they were cussing and arguing. And that Mr. Simpson was not shy about saying that he walked up and began fighting with defendant one. He threw the first punch, and the fight, as he described, ended up into the gas station, or they went into the gas station as they were fighting. Mr. Simpson then testified that he knew defendant one from the gas station from working there, not that he was the owner, but he knows him from the gas station being employed there. And that something was said in a foreign language, defendant one was speaking to defendant two, and then defendant two passed what he described as a handgun through the turntable, as described with the bulletproof glass up and turntable where people can receive their goods after the clerk marks or checks the price. And the defendant two passed the handgun through that turntable. And at that point, the complainant witness, Mr. Simpson, took off running and saw nothing else. He said after about 5 to 10 seconds, he was shot. And then he heard multiple shots, and quote, numerous shots, 4 or 5. They ran to cover in another store about a block away. And that the clerk, the store would not let him behind the glass. And then he saw defendant one with that gun. And the defendant one said, "I should kill you." Mr. Simpson was at that point shot in the right foot in the back, as he described. And then he waited in the store and did not leave out of the store until the police came. And the defendant had the gun, pointed it, and said, "I should kill you," something of that nature. Mr. Simpson was sent to St. John's Hospital, released on the same day. And also that defendant one was recording, or Mr. Simpson believed that defendant one was recording while arguing with Ms. Harrell. So as defense counsel has brought up both different issues, For defendant one, it would be whether or not A1 is the appropriate charge. I'll start with that issue first. So with the facts we have here, that defendant one received the gun from defendant two through the turntable. Plaintiff witness did not see the defendant number one shoot the gun. There was testimony that Mr. Simpson saw the defendant with a handgun, that 5 seconds later, he was shot in the foot, also that he heard 4 to 5 gunshots, and a block later, or we ran a block down the road to another store, that defendant number one had a gun in his hand and said, "I should kill you." There's no testimony of anyone else having a gun or a weapon, no one else part of this altercation physically. There was no testimony that defendant one came from behind the glass and assisted as far as physically shooting. And I believe that's circumstantial evidence for the probable cause standard that allows for this to be found out and the people have met their burden of proof. And with that, of course, felonious assault will be has been met as well. I do believe there was it is a specific intent crime, and as the people have stated, a bad shot is not a defense. Defendant one, according to testimony, shot 4 to 5 times while Mr. Simpson was running with his back to the defendant number one. And just because he was not successful, I do believe, based off testimony, that he had the intent to kill and not to just injure. A gun is a deadly weapon, and I don't know what one of the better examples to show that you want to kill something. And as far as aiding and abetting for defendant number two, as defense counsel for defendant number two, Mr. Bartell, read off the elements of or what's necessary for the people to prove aiding and abetting. One, that the crime was committed. Two, that the defendant did something to assist. And three, that the intended commission of the crime, or knew that the other person intended its commission, or the crime was a natural and probable consequence of the commission of the crime intended. So I believe the people have met all of those. I mean, it's all met with the elements because one, the crime was actually committed. Two, that especially two, during the crime, defendant number two did something to assist in the commission. He handed defendant one the handgun. And if that handgun had not been handed over, this may have ended it. And three, the last part of the element states that the crime alleged was a natural and probable consequence of the commission of the crime intended. I believe here, based on the testimony, handing over somebody a gun during a fight, I'm not sure what else someone is going to do with that other than, and in fact, other than shoot or intend to harm and kill. The fact that Mr. Simpson ran and the defendant number one continued to pursue also supports the intent as well. So with that, I am going to add the charges that the people have requested. That would be for defendant number two, adding assault intent to murder under the aiding and abetting theory, as well as another felony firearm count. And have both defendants bound over on all counts for an arraignment on the information for February 15th at 9 o'clock.
Judge, may I respond?
Yes.
Judge, may I inquire as to what the bond is for these two defendants?
Sure.
How much is your bond? How much is your bond? It's $500,000 for my client, Judge. It's had no issue. We've been here probably about 5 or 6 times, so.
I don't have any number on here, any amount. Mr. Martell, do you have the bond?
I do not, Judge, but notwithstanding, the 2 added counts, Judge, again, is with defendant number one, my client is here, ready to defend time and time again, and we will move forward with same defending on the merits. We have retained counsel, local resident. Judge, I would ask to leave the bond alone and let the circuit court address if necessary.
Okay, before you begin, can I get the ROA so I can have the exact amount? I'll look it up. on September 2nd of 2022, bond was set at 500,000 for Mr. Al-Alami, as you stated,
Yes, sir.
and for Mr. Ishak Al-Alami. Let's see. It's at 10,000, 10%.
Anything else? Yes, Your Honor. We're asking or seeking to increase both defendants' bonds. This time, the court has now heard the testimony. Has heard how egregious the defendant's actions were. As the defendant number one, particularly egregious that he ran after Mr. Simpson a full block into another business with his gun and shooting at him. This is an individual who is a danger to a community, a person who doesn't know how to handle a conflict, and when faced with a physical fight, grabs, goes for his gun and starts shooting an individual from behind as he's running away. This defendant, we believe, is a threat to the community, and we're asking that the bond be increased to $1 million. As to defendant number two, I'm asking that a $500,000 bond be put in place, given that his actions assisted and aided and abetted in defendant number one's actions.
Judge, can I respond? Mohammed Nasser for the record. Judge, I'm perturbed by that because in essence, the people are saying that my client exercising his statutory right to a preliminary exam should automatically lead to a bond increase. $500,000 is a significant amount of money. This incident happened almost a year ago, August 31st of 2022. We are now sitting in February of 2023. We have been here no less than 3, 4, 5 times that this matter has been put off continuously. And what fine sister counsel hasn't indicated in her request for an increase is that all of these allegations were made at the time of the bond hearing, which is why the bond is so high. My client is a business owner, zero criminal record whatsoever. More importantly, Judge, that he has been present every single time. There's been zero bond violations, zero. So to now ask for an increase, Judge, we're talking about a $500,000 bond here. That these are allegations that this court found probable cause. Absolutely. We have motionable issues undeniably, and ultimately this matter may take its course perhaps all the way to trial. But that being said, Judge, bond is flight risk, danger to the community. Flight risk, I think this court would agree, and I don't think sister counsel is making the argument that he's going anywhere. The charges are the same that we walked in, that we're walking out with. As it relates to the danger to the community, judge this individual by his conduct while on bond. He's here, aptly dressed, timely made his court appearance. Yes, ma'am, no, ma'am, and he's prepared to defend his case, Judge. There is absolutely no basis to increase this bond, and I'm asking that you keep this substantial bond of $500,000 in place, and he's shown his good faith by showing up every single time and having no contact with this complainant, nor will he have contact. He hasn't gotten a parking ticket since we started on August 31st, Judge.
Oh, do you want to respond?
May I, Your Honor? Your Honor, defense counsel raises this matter was, adjourned many times. I'm going to point out that none of those adjournments were as a result of the request. I further add that this is not a vindictive request, as defense counsel has alleged, that because the defendant exercises his right to a preliminary exam, that we are asking to increase the bond. What has changed now is that the court's now heard the facts from the witness himself. As such, when there is new information to be presented, the people are able to raise the issue of bond again, and that is exactly what the people are doing. This court has heard the egregiousness of what has occurred, has heard it straight from the witness at this time, and for those reasons, we believe that this court is in a position to listen to bond, to hear bond, and to address the bond and increase the bond.
Thank you, Judge, if I may. I certainly would join in with the sentiments of other counsel. But the overarching question for this honorable court is my client going to show up for court? And does my client present any additional dangers to the community than he did previous to this here examination? And the answer is no, Judge. My client has no prior criminal conduct. He's an employee at the gas station. Certainly he's been bound over by probable cause, Judge, notwithstanding the additional charges, Judge. Again, he certainly will be ready for court, ready to address this on the merits, has retained counsel. Judge, I'm asking this honorable court to keep the bond and what it currently is and allow the circuit court to address if necessary. Our argument is certainly it is not necessary, Judge. We are prepared to move forward. Our clients will be present, and certainly they don't add any additional dangers than they did at 11 o'clock. So our request of this honorable court is to let the bond remain as it is, Judge. Thank you.
And may I add just one final thing, just so this court is aware, Judge. Judge Larry Williams actually heard a bond argument and granted our bond argument to remove his GPS tether. That's how much good faith, and again, hearing the facts as they are, Judge Larry Williams thought it fit to remove that GPS tether as well. So he's shown good faith, he is present, Judge, and we're ready to proceed.
Well, you know, we're all different.
Understood, Judge, understood, we are.
So I've heard arguments from both parties. My only question is, has anything changed as far as contact between, has there been any contact between the complaining witness and
Zero.
That to me was the only thing that mattered. So with that, I am not going to adjust bond. Neither one of the defendants have any criminal histories. There's no flight risk, and I know the charges are their allegations. And if this was at the arraignment stage, I may have had a different response. But this has been over a year now, and I have not seen anything in the file stating that there are any issues with the complaining witness or anyone else, no other pending cases. So I'm going to leave bond as it is.
Thank you, Judge.
Thank you,
Anything else?
Nothing further to request, Judge. We thank this honorable court.
And I also want to put on the record too, and that goes both ways for no contact, complaining witness as well as the defendant, seeing that they're in the same community, and I believe defendants are still working at the gas station.
Yes.
Okay, so it's no contact. Thank you, Judge.
Thank you, Judge.
Thank you, Judge.
Okay, we're on the record. Oh, I'm sorry, we're not on the record. Sorry, Mark. Okay. Okay, we're on the record as the people of the state of Michigan versus Richard Anthony Benitez, 2256718. Mr. Benitez is charged with count one, stolen property, receiving and concealing $20,000 or more. This is a habitual offender report that's been noticed. Today is the date set for a written examination. Appearances.
Alexander Kircher on behalf of the people, P86280.
Good afternoon, Your Honor. Nancy Cassidy from Neighborhood Defender Service of Detroit, appearing on behalf of Mr. Richard Benitez, P number 80549.
Are you ready to proceed?
Judge, unfortunately, Mr. Benitez is not in court. The court officer has called out his name as well in the hallway, and he was not present. I don't have an explanation for why Mr. Benitez.
Have you spoken to your client at all?
Judge, we made contact with him previously, but that was the extent of it.
Okay, so he has been notified of the same thing.
I believe so.
Yes, cases too. So I'm
That's
going
my
to issue
granddaughter.
cases. I guess I should let the people speak first.
Well, we would ask for two.
Okay. That's what I would do.
That's beautiful. Thank you. Big bag, big bag.
So it'll be personal 5,000. That's based on the prior cases on May 3rd, 2022. And also for the record, the exam is scheduled for 11:30 South Local.
And Your Honor, just for the record, I just wanted to state that I myself have not personally spoken with Mr. Benitez. And so the court had asked me before if he knew about his court date today. I can tell the court that attempts were made to get in contact with Mr. Benitez. But I don't know if he knows of his court date today. Okay, I just wanted to clarify that.
Very well. Then I'm gonna keep numbers the same. Anything else?
Nothing else on behalf of the defense, Judge.
Okay, all right, we are concluding today's case.